because I think this is an important bill. Many members have raised a range of issues, and it broadly falls within three themes. First, on the need for the CLTPA in today's context. The second, on the manner in which the CLTPA has been used and the release of information pertaining to the use of the CLTPA. And finally, on the safeguards that govern the use of the CLTPA. And I will address these in turn. Madam, this debate, the extension of the CLTPA for a further 5 years, serves a very important purpose. It allows the Minister to account to Parliament for the nature and extent of use of the Act and to provide a detailed explanation as to why the Act remains necessary in the prevailing environment. Its temporary nature is not simply a matter of nomenclature. Rather, it compels a periodic reminder and discussion within Parliament and without on the powers under the CLTPA and the need to review its continued relevance. So I therefore disagree with Associate Professor Eugene Tan's characterization of this process in this debate as a legislative ritual. Far from it, it is a robust debate, as in fact evident from today's proceedings, that needs to take place every 5 years so that members of Parliament, and indeed all Singaporeans, fully appreciate the nature of the criminal threats that we face and the powers that are needed to maintain public safety, peace, and good order that we deeply value as a society. So let me reiterate the reasons we continue to need this Act. I'm glad that members in general acknowledge that we must remain vigilant even as the crime situation improves. As mentioned by members like Mr. Ang Wei Neng, the threats posed by international criminal syndicates involved in illicit activities such as drug trafficking have by no means been eradicated. Instead, they are evolving their modus operandi and becoming more sophisticated to evade capture and prosecution. Every time an arrest is made, the syndicates quickly adapt and adjust their operations in response. The recent experiences of other countries reinforce the dynamic and pernicious nature of this threat. Several members, Mr. Hari Kumar and Mr. Vikram Nair in particular, have cited the example of Malaysia, where the emergency ordinance was repealed in 2011. However, in just 2 years, they have found it necessary to restore detention provisions in their laws to bring the worsening situation of violent crime under control. Mr. Chris D'Souza mentioned the situation in Australia, where biker gangs have been responsible for violent crimes such as brazen public shootings and clashes with rival gangs. Tough anti-biker gang laws were recently passed in Queensland to address the lawlessness caused by these established criminal groups. In Singapore, we cannot afford to merely react to the situation after the impact of a pernicious criminal threat has become fully apparent. We have an imperative to act swiftly and decisively, especially given our circumstances as a small city-state. And I don't think this is just an argument about Singapore's exceptionalism. It is, I think, an honest assessment of the realities that we face. That is why we need the CLTPA and the powers it affords our enforcement agencies to deal with such syndicated criminal groups. Mr. Hari Kumar has asked about the relevance of the CLTPA in the future, given that the Ministry of Home Affairs is developing legislation to deal with organized crime criminal syndicates. An Organized Crime Act is being considered with a view to enhance powers to deal with criminal syndicates and strengthen our ability to disrupt their activities. But I must emphasize that any organized crime legislation will serve to complement the CLTPA and it's not intended to replace the CLTPA, much like we have the Misuse of Drugs Act in the context of drug trafficking. The CLTPA will continue to be necessary and relevant in addressing serious criminal activities, especially where it is not possible to prosecute persons in court because witnesses are fearful or unwilling to testify. Associate Professor Eugene Tan has asked for an articulation of the circumstances and conditions under which the CLTPA may be abolished. I think it is neither possible to do so, nor, in my opinion, is it something we should attempt to do. Criminal groups reorganize and rework themselves constantly. This is the experience of all our law enforcement agencies. And new forms of serious criminal activities evolved in a borderless world, assisted by advances in technology. Thus far, the CLTPA is and has remained an effective measure in our context to deal with serious criminal elements. So the circumstances warrant it, they are dynamic, and I think it would be unwise for us to set specific conditions without knowing how the situation would evolve in the future. But I will assure the member and all members of this House that the government will always make a rigorous case based on a thorough assessment of all circumstances and the criminal landscape each time we seek Parliament's approval to extend the CLTPA. Several members have also raised the questions pertaining to the scope and application of the CLTPA. Mr. D'Souza has described the CLTPA as a tool that enables our law enforcement agencies to proactively deal with criminal activity that threaten the safety and security of Singaporeans. This is critical in the face of the kind of criminal activities that continue to pose a challenge to our society. Mr. Eugene Tan and Ms. Sylvia Lim have expressed their concerns for the rights of individuals who may be detained without an open trial. And I think this is a concern and a cautionary note that all members of this House share and would sound. But the equally valid countervailing consideration is the impact such criminal acts can have on victims and the broader society if they are committed with impunity and the perpetrators not taken to task. We must find a balance between the rights of individuals and the need to preserve public order. I want to assure Mr. Edwin Tong and indeed all members that the powers under the Act are used judiciously against serious criminal activities and where it is necessary to do so, as stated in the Act, in the interest of public safety, peace and good order. This is a point that the Ministry of Home Affairs has made several times in the past, and it is a matter of parliamentary record. Neither should we, as Ms. Sylvia Lim suggested, interpret public safety, peace and good order as merely referring to danger to life and limb. That is one important consideration, but indeed there are many other elements that contribute to an assessment of what constitutes a threat to public safety, peace and good order. It has not been used, the Act, and not meant for non-criminal matters, as Professor Tan has suggested. The fundamental tenet remains that court prosecution is the first and preferred course of action, and the Act is used in a calibrated and targeted manner only as a last resort. These were the same considerations in the decision to use the CLTPA to deal with the members of a match-fixing syndicate in October 2013. While I'm unable to go into the specifics of this case, as some members have observed because it is still in process, I will address some points that have been raised by Mr. Hari Kumar, Mr. Ang, Ms. Sylvia Lim and Mr. Pritam Singh in general terms. Fundamentally, match-fixing syndicates operate no differently from those involved in drug trafficking or unlicensed money lending, and they share some of the most egregious characteristics that render them a threat to public order. Yes, some members have said, they have complex and layered structures, use technology and other means to avoid detection, and are motivated by financial gain. And the implied question is, but so what? They also have links to other transnational criminal syndicates. They are also known to resort to violence and other means to settle scores against those who stand in their way. At the same time, the transnational nature of the activities does aggravate the difficulties we have in securing witnesses willing to cooperate and testify against the syndicate in our courts. This is a fact. We cannot afford to consider match-fixing or transnational crime another country's problem. Organized crime syndicates often collaborate and have links with syndicates in other countries and are involved in a whole plethora of businesses. If allowed to take root, this kind of criminal activity will cause a profound decay in public order in Singapore. Ms. Sylvia Lim has asked about the extent of collaboration with other jurisdictions in tackling the problem of match fixing. This is an important point. Our agencies work together with their international counterparts. There's exchange of information and intelligence. If we receive a request for extradition, and this is allowed for in the law, we will extend our fullest cooperation to other countries in accordance with the law. But it does not change the fact that our agencies need to act decisively to cripple illegal activities of such syndicates. I want to caution against taking the view that match fixing is simply a case of cheating or corruption with no threat to life, limb, and security. On that basis, unlicensed money lending is also simply a financial transaction between two parties. However, we are all well aware of the deeply harmful spillover effects of the scourge of loan sharking and associated activities, and the threat that they pose to public safety, peace and good order. Mr. Kumar, Mr. Ang, and Associate Professor Tan have also asked whether we can give a more detailed update or even an annual report on the use of the CLTPA. Let me just reiterate some of the facts that I shared in my second reading speech. The majority of inmates have been detained for less than 4 years. Long detentions of over 10 years are only used in exceptional circumstances. There is currently one detainee who has been detained for close to 11 years for being involved in drug trafficking activities. From 2009 to 31st October 2013, close to 300 police supervision orders were issued under the CLTPA. This includes persons who have been released from detention in prison. Mr. Tan has also asked about the recidivism rate of detainees. In general, the recidivism rates of detainees generally lower than that of the broader prison population, and it could in part be due to the PSO regime that we have. However, the key point is there is a range of provisions, and moving forward, we also intend to release relevant statistics on the detentions under the CLTPA on a more regular basis as part of the Singapore Prison Service annual statistics release. Mr. Ang has also asked if it was possible for MHA to inform the public on the frequency with which the advisory committees have summoned and examined witnesses. Madam, the need for advisory committees to do so is dependent on the circumstances specific to each case. Hence, such aggregate or average information would not be very helpful. The advisory committees comprise individuals with legal training, and they work independently of the Ministry of Home Affairs, as Mr. Edwin Tong has stated. They understand the general rules and the need for adequate evidence, and I assure members that we give the committees our full support so that they can do their work. Finally, members have also mentioned the need for strong safeguards under the CLTPA. I fully agree with all who have said so. The powers under the Act are wide-ranging, and therefore we need strong safeguards. I have elaborated on these safeguards earlier, but I think it bears repeating. First, it is an important fundamental safeguard the government must seek Parliament's endorsement to extend the CLTPA every 5 years. It provides for periodic parliamentary scrutiny and ensures that the CLTPA continues to be relevant in the present operating environment. It's also an opportunity for us to remind ourselves that we do not operate in a benign environment and must remain vigilant. Second, the assessment of each case is deliberate, with comprehensive checks and balances, with several independent parties and committees involved at each stage. Each case is reviewed thoroughly before an order is issued. The order is for a duration of up to 1 year in the first instance. Mr. Edwin Tong asked how the Minister can be reasonably satisfied that criminal prosecution is not possible. First, the law enforcement agencies themselves know that they need to abide by the safeguards, and they investigate each case thoroughly, no different from any other case that they investigate. Specifically, each proposal from the enforcement agencies, together with the evidence that has been gathered, is first scrutinized by senior officials in the Ministry of Home Affairs. The Attorney General's consent, in his capacity as the public prosecutor, is also required for the issuance of orders by the Minister for Home Affairs. There have also been instances where ministry officials or the Attorney General have disagreed with the recommendations for detention by the law enforcement agency. Third, the orders are reviewed by criminal law hearing committees, which comprise distinguished members from the community and the legal profession, including former High Court and District Court judges. Mr. Nayar's proposal to have at least one former judge chair each committee is a good one, and we will take this into consideration in looking at how we can improve the system. The review process is thorough and rigorous. Committee members may examine detainees, investigating officers, and witnesses. They have untrammeled access. Detainees are informed of the case against them and have an opportunity to present their case to the committee or through their legal counsel. On this point, we also note Mr. Tong's suggestion for assigned counsels for persons dealt with under the CLTPA. I understand that the Ministry for Law has been generally looking at enhancing criminal legal aid, and I think we'll be able to announce its position on this soon. Having scrutinized the evidence and the facts of the case, the committee will submit its recommendations on whether to cancel, vary, or confirm the orders. Members have asked for the number of instances when the final recommendation was in variance with the original detention order. This question poses an interesting dilemma. If there were many instances, the conclusion would be that the system is not working. If there were no instances, a similar conclusion would also be drawn. So the answer really is one that has to, one that cannot really satisfy the level of curiosity that some members have expressed. But I will say this: there have been a number of instances where the initial detention orders were cancelled and police supervision orders subsequently issued in their place in view of the committee's recommendations. Each detention order is only valid for up to 12 months, and each case is then reviewed annually by a criminal law review committee. Members of this review committee are different to those of the initial hearing committee. The review committee will similarly submit its recommendations to the President on whether to extend or vary the detention order. And the President then acts on the advice of the Cabinet. Each extension of the detention order is for a period of up to 12 months. Mr. Ang asked how the length of detention is determined. In making its recommendation, the Criminal Law Review Committee considers a number of factors, including the nature and gravity of the offences committed, the detainee's criminal antecedents, conduct and response to prison's rehabilitation programs, and the likelihood of reoffending and continuing to pose a threat to safety and security. The assessment is holistic, specific to the circumstances of each case and each individual, and the various factors need not carry equal weight, nor does any single factor outweigh the others. Yet another independent advisory committee is the Criminal Law Review Board, which reviews all cases of detention beyond 10 years. And the board comprises members who are different to the review committee and the hearing committee, And this process ensures that cases where persons have been detained beyond 10 years are scrutinized by a separate committee and that they have not been detained longer than necessary. Ms. Sylvia Lim suggested that judicial review cover the merits of detention as well. But that's not been the intent of this legislation from its very outset. Parliament has conferred on the executive the power to issue such detention orders, and the judiciary's role is limited to the review of the procedural integrity and rationality of the processes. That is also why we come back to Parliament every 5 years, because of the temporary nature, to account to Parliament, for Parliament to vest that authority, renew the authority that is assigned to the executive. She also drew comparisons with the Malaysian system of detention. The detention provisions within the Prevention of Crime Act in Malaysia have to be renewed by Parliament every 5 years. The members of the Prevention of Crime Board are appointed by the Yang di-Pertuan Agong for a term not exceeding 2 years. The Yang di-Pertuan Agong acts in this instance on the advice of the Cabinet. If you contrast this with the Singapore system, Parliament explicitly vests the authority for detention under the CLTPA with the executive, who is then clearly accountable to Parliament for the use of the Act. You have to compare this with what is the accountability for a committee appointed for 2 years in terms of the exercise of powers accorded to it under the Prevention of Crime Act. At the end of the day, it is a system that needs robust safeguards, checks and balances, and people of integrity who are involved in ensuring that we're doing the right thing in the right way. Associate Professor Tan proposed removing the provisions on essential services in Part 3 of the CLTPA and incorporating them under other legislation such as those dealing with employment or trade unions. Some clarifications are in order, and I agree with the member that this may not be the most elegant legislative solution. But to clarify, the detention powers under the CLTPA are applied judiciously and only in situations where it's quite clear the threat to public order. In practice, these powers have not been used for strikes and lockouts. Second, the provisions on illegal strikes and lockouts in essential services, unlike those on detention, those who commit an offence under this section are dealt with through court prosecution, as was the case recently with the SMRT strike. The penalties are also clearly spelt out, such as a fine, maximum of $2,000, and imprisonment of up to 12 months. The provision on illegal strikes and lockouts sits independently from those on detention. Third, these provisions on strikes and lockouts in the CLTPA are specific to essential services. It prohibits strikes and lockouts in 3 sectors: gas, water, and electricity. As for the other essential services such as public transport and air transport, broadcasting, and banking, which are listed in the first schedule of the CLTPA, workmen or employers who wish to take part in a strike or initiate a lockout must give a 14-day notice period. This notice period is required to ensure minimal or no disruption to services which are necessary for the proper functioning of critical operations in Singapore. These are not provided for in other legislation such as the Trade Unions Act and the Trade Disputes Act. And I believe that these provisions are still relevant and appropriately placed within this Act at this juncture, but legislation will constantly be reviewed, and if there's an opportunity that is suitable, we will consider the member's point. Madam, I want to conclude by thanking members for voicing support for the extension, members who have spoken for voicing their support for the extension of the CLTPA. I know that this is a difficult decision. Since its inception, the CLTPA has been essential in allowing our law enforcement agencies to act decisively against evolving criminal threats, and they are constantly evolving their modes of operation and manifest themselves in different forms. What remains common across all of these threats, whether it's secret society activities or drug trafficking or other types of criminal syndicates and criminal groups, the consequential impact on public safety, peace, and good order is beyond question. The experiences of other countries underscore the need for the CLTPA. It provides us with appropriate powers which can be used in specific circumstances. In practice, the Act is applied judiciously to a targeted group of persons associated with activities of a criminal nature and where it is in the interests of public safety, peace, and good order. Court prosecution is and will continue to be the norm. Powers under the Act will be used as a last resort. This is why there has to be an elaborate system of strong safeguards and multiple checks and balances to ensure that the Act is used judiciously and the powers not abused in application. I have elaborated at length on this because it is important the members of this House appreciate that we do not take these powers lightly. Madam, ultimately the essence of today's debate is really about ensuring safety and security of Singapore for present and future generations. And the CLTPA is an integral part of our efforts to do so. I hope that we will